Adjournment request, if any, from item number 1 to 8. From item number 9 to 20. Adjournment request.
Allowed with the consent of the other side, back to mention item number 14.
You have circulated this already.
My lord, may I pray for a date?
I give you.
Lordship, we have filed an IA. The IA, my will be
28 July.
taken up with the main item in the next day.
Take it.
Wait, 20. From item number 21 to 26.
My lord, in item number 26, I'm appearing on behalf of the respondent number 6. And I'm filing an affidavit in this matter today, madam. Can it be called for?
No, Lord, let it come next item, my lord, because I have to go through it, madam.
As prayed for on behalf of respondent number 6. And agreed to by the legal counsel for the appellant. Let this matter come up for consideration on next Friday.
29-5.
Pledge.
This is that nomination.
My lord, nomination.
Who stands nominated? You.
My client is nominated.
All right, we'll see.
With the concern of the other side, I'm going to mention item 23, madam.
23, you have circulated my slip. All right.
Well, 23, it's for fixing of interim, can it be next week, madam, a specific date, madam? There is other say because
Next to next week, next week, June, next Monday. Next Monday, it's in June.
For sure. 1st June.
I
1
love
6.
this one.
My lordship, this is regarding item number 20.
Hmm?
Item number 20.
20. What do you want?
That the same player, the respondents may be, the process may be issued against the respondents. And,
What process?
you mention you?
okay.
What do you want?
No, I was
Huh?
a little confused about the daily is. I'll be. Wait a minute.
Please, Lordship, with the consent of the other side, I beg to mention item number 25 of the daily list, Lordship. Lordship, we've taken consent of the other side, but no adjournment has been circulated, Lordship.
25.
25,
Have you
Lordship.
informed Mr. Bhuyan?
Yes, Lordship, I have informed Lordship. Please, no objection, Lordship.
As prayed for on behalf of the respondent. / Secondary Education Department. Let this matter come up for consideration. On. Sometimes later.
Lordship.
Like
July. 22nd July.
yes, challenge the application.
Any other request?
I went also for listing on 8 April, on 2nd week of June. 8 April.
When did you file it?
It was only last posted on November.
It will be coming for the first time.
Yeah, no.
No, last
Second time.
posted.
Last posted on?
In the month of November 2025.
Yes, second week of. Second week of.
Yes. Let's say praying for a listing of fresh PIL matter. Similar matter is fixed on Monday before the Lordship's matter.
Monday.
I'm obliged with.
Lordship, item number 3 of today's list.
Item number
3.
Item number?
3.
33, 3.
3.
Yes, what do you want?
Lordship, in this case,
Let it be called out. Cases under orders. No mentioning is required. Let it be called out. Then you take time. Yes.
daily list for orders item 1.
It's an application file for deletion of.
My lord, on last occasion, my lordship allowed me time to file affidavit application for deletion of name of respondent 7 and 10. And so far I could not file my lord because the petition was unwell. I pray for further 2 weeks time, my lord.
As prayed for on behalf of the. Is what? You appear for whom?
Petitioner.
As prayed for on behalf of the petitioner. Re-notify after 2 weeks. One paragraph petition.
On behalf of the state respondent, we have filed the affidavit today.
17th June. Item 2.
Yes.
So, Malab, here, the other side has appeared now. Issue is a very small matter pertaining to DRT refused to condone the delay of 25 days. Therefore, 40 days, 24 days, 24 days. So, while considering the review petition, there was a review petition filed by us, and there was a delay of 24 days. And the
Yes, what do you have to say?
Your Lordship, the issue that has been raised is already been decided in the Supreme Court.
That's something else.
It's, Your Lordship, it is very similar and
It's correct, but why not condone the delay of 24 days when he's showing? Yeah, any reason assigned?
no power, Your Lordship.
Huh?
DRT has no power, Your
Where is that decision?
Yes, sir. That is 2020, 13.
Where is that shown?
Show
Show it to us.
Yes, sir. So, Your Lordship, the fact.
Bring it tomorrow. You bring that,
subsequent
not tomorrow. Tomorrow, that's Monday. Let
Yes,
this
sir.
matter come up for consideration.
Monday, I have some personal
Tuesday?
ticket. So my juniors will be here now. Because I'll have to undergo some medical procedure.
Next week.
Next week,
Next week. Next.
on Friday,
Any day, first week of June, second week of June, whichever is.
5, 6, 5th June.
5th June. Yes. It will come up for admission cost.
No.
And order.
Item 3 and 4.
You bring that, give that judgment to us
Yes, sir.
today.
Yes, Your Lordship. Has been given, Lord.
Yes.
Admission amount below.
Who wanted time? Yes, Mr. Sharma, what do you want?
Your Lordship, in this case, what was happened on the last occasion, Your Lordship has directed senior advocate Sir K.N. Chaudhary to be present before Your Lordship.
For what reason?
Because Your Lordship, we have filed a review application.
All right, as great for on behalf of the, on behalf of
Review application.
the review, on behalf of the applicant, on behalf of the petitioners, on behalf of the review petitioner, let this matter come up for consideration. 19th June.
Because my this petition is also intact with it.
All right, along with what?
Item number 5.
Should the judgment sought to be reviewed or not, you will find at page one review on the ground certain facts, my lord, apparent on the face of the bond out of the record, my lord, that has not been considered by your lordship, my lord. Because the earlier council might have not pointed, lordship. Lordship may come to page 160, my lord, the judgment sought to be reviewed. Lordship, page 163. The petitioners herein are casual
Which
workers.
paragraph?
They are casual workers and working for BSNL. They approach CAT manner, paying for grant of temporary status and resultant regulation in terms of the scheme. The scheme is called, my lord, Casual Laborers Grant of Temporary Status and Regulation Scheme of Department of Telecommunication 1989. Now, my lord, let us see the operating part, my lord. 169. Page 169. Paragraph 29, my lord, last paragraph. Resultingly, it is held that the petitioners are entitled to a grant of temporary status from the date they completed 240 days of service in accordance with the scheme of 1989. The respondents are further directed to confer such status with consequent benefits. The respondents shall thereafter consider petitioner's case for regularization in terms of the scheme. My lord, let us first understand the scheme, my lord. The lordship will find the scheme at page 81, my lord.
I don't think you have made out a case for review. Challenge it.
Because, my lord,
Challenge it before the Supreme.
my lord, The scheme is for 40 days, my lord, and moreover, my
That's all
lord,
right, but.
they are casual neighbors. Lordship, I am pointing out what,
Everybody hearing.
I am pointing out the, my lord,
Please go
things
back.
that have been left out of record, my lord.
Dismiss.
Moreover, my lord, there is Supreme Court decision, my lord.
All right,
Take place now, my lord.
challenge this order.
Item 6.
I have received the condemnation petition. Let it be taken after 2 weeks. If so advance, then I file the. No.
It's a delay of 20 days only.
Opposite or you concede
It's okay.
for the reasons stated. Delay condoned, the appeal to be processed. Take the appearance notes.
27 July.
Yes, proposal.
Item 7.
Yes,
My lord, I have entered appearance in this matter today on behalf of the respondent, my lord. I have not served with a copy of the IA also, my lord. So I'll pray for some time to file my objection.
that's Monday.
My lord,
Monday,
I'll file
48
my
days.
objection, madam.
48 days.
48 days delay, what? It's all right. Give him a copy
My lord,
today.
I'll.
We are condoning the delay. We may condone the appeal to be processed. And preferably listed also.
I may be served with a copy of the memo of evidence and I'll do it.
5th August. ID.
Obliged.
Item 8.
You can see this.
56 days delay, lordship service complete. Similar to.
Nobody is here.
I'm very sorry, Doctor. I'm appealing for the sole respondent.
We
I
are
do not have
condoning
any,
the delay.
do not have any objection in respect of that.
7 August.
Similar to speaks on 21/7.
21/7. 21/7. Item number 9.
DB3 में हम direction dates का list करने के लिए for instance.
May pleasure, lordship. Lordship, matter may be timing, put us something, my lord. In anything on like.
You directed to list it before. What is the main reason?
Yes.
What is it for? What is this IA for?
Yeah.
For remission of the amount of cost imposed on the applicant.
Which is item number?
Item number 9.
What do you want?
My lord, something, the something, matter may be timing, my lord. My scenery.
I can't.
Timing.
For the time being.
Yes, madam.
This interview is listed before original cheaper from because the performance method is cost imposition.
No, let this, why has it been listed here? It was supposed to be listed.
Actually, yeah.
3.
It actually matter may be, before the appropriate bench, my lord.
By order dated 6/4/2026, this court had directed the above noted interlocutory application to be listed before DB3 for consideration, preferably on 4/5/2026. Stop. Let this application be listed before DB3 for consideration. Preferably on
That will fix, my lord.
12th of June.
Obliged, lord.
Item 10.
Lordship, 9 days delay in filing the.
I'm with Gulal and notice to which respondent?
7.
PNID given.
Respondent number 7, private. Rest is accepted by Mr. Doctor.
Yes,
Mr. Datta, accept notice if you have fathers. And 7.
my colleague is also.
Notice to be issued.
You give the names to him.
The requisites within 2 weeks, both modes returnable. July end or August.
7 August. Item 11.
May please also. A delay of 360 days in preparing the appeal.
State, all state respondents.
My lord.
Yes,
Mr. Doctor and GS.
notice accepted. You want to respond?
360 days.
Yeah. Are you going to oppose this? So we, all right. Delay condone, they have set.
Oblige, your lord.
10th August. Item 12.
This means the track reports is all going. Really good recently, so.
Yes,
All is appeal.
Challenging the interim order passed by the appellate tribunal Kolkata, my lord.
you're appeared now, Mr. Sharma. Mr. Sharma appears for so and so
115.
for response number 150. Notice complete then?
Yes.
No other respondent is noticed? The service of notice of respondents is complete. Let this matter come up for consideration under the heading admission. On, give a date.
24th June. Supplementary list item 27 for order.
Will be spending on them.
There is a stay on the operating lodges.
Yes, I'll keep it. Awaiting the. Here. For the reason of dependency of SLP in the connected matter before the Honorable Supreme Court. Let this matter come up for consideration sometime on August 10th.
Apply.
24th August. Both the matter.
Both the matters.
Yes.
Daily list item 13 for admission.
May please, your lordship.
Yes.
My lord, public inconvenience is there. They are proposing to construct
Are there any?
building in a area which is one-sided and waterlogging, having no communication facility.
We are not going to get into that. Now tell us if there are any rules in that regard for selection of the site.
My lord, there is no such provisions, but the Panchayat,
Then let that be the.
Panchayat,
decision.
it is a part of developmental activities. And any developmental activities, it's taken a resolution by the body. That has not been.
Mr. Sikdar, the selection of site and the selection of the location for Panchayat Bhavan. Normally, in different jurisdictions, they have rules that it should be government land. If not government land, then private land, which is in the headquarters of the Panchayat. If not, then some place where the footfall is more, things like that. If you don't have any rules, then we go by the selection of the competent authority. They have selected it.
My lord, competent
what
authority is the
ground
my
can
lord,
it be questioned?
Panchayat body. There is no resolution. The petition number 2, he is also one of the ward member. He doesn't know when resolution was taken.
Because that must not.
It is imposed, simply a politically imposed, my lord. It's a
that-
political decision.
All right, so what do we do? We
My
select
lord,
the place.
Let it be decided by the Panchayat body.
That will cause impediment in the construction of the Panchayat Bhavan. Yes, you tell us how do you select?
Why not?
There has to be some reason, no, for selecting a particular place.
But
What is the reason? And how a Panchayat member does not know that resolution to that effect was taken?
that is within the PRI bodies, my lord. I cannot say.
Give us, respond to this particular.
Because my lord, the main grievance is against the private respondent, the president, respondent number 5.
The petitioners are residents of Chandinagar Gaon Panchayat under Katigora Development Block in the district of Kachar. The grievance of the petitioners is that Panchayat authority, that that new Gaon Panchayat Bhavan is being constructed at Korait Kandi, Part 1 village. The contention of the petitioners is that the decision about the location / site of the Panchayat Bhavan has arbitrarily been taken by the president of the Panchayat without any resolution by the Gaon Panchayat body. The issue was never discussed in any meeting of the Panchayat or its standing committee as required under the Assam Panchayat Act 1994. The other objection is that the chosen location would be highly inconvenient for the majority of the residents. The site chosen, according to the petitioners, is a low-lying area which remains waterlogged for most of the year, with practically no connectivity. The chosen site is approximately 5 kilometers away from the main road, which would cause great hardship to the majority of the villagers who would have to travel long distances to visit the Panchayat office. Mr. S. Datta, Standing Counsel, PNRD Department, seeks some time to respond to this petition.
No, sir, may I kindly come to case number
He
20?
is not interfering with this.
Case number
Let's see
20.
what is the process? I mean, what is the procedure adopted for selection of site? You don't have any case.
Yes, already.
Foundation is over. You decide. You say what is the reason? Government land,
Only 2
land
months.
at less cost. Otherwise,
Yes.
I mean, all these are reasons.
Yes.
Development.
I just.
Item 15.
That's it. Honorable Single Judge, this is my petition. And prior to that, there are two different orders passed by Honorable Court in the bench. Page 414 and 426, man, kindly put it.
Who are you?
414 and
Who
426.
are you?
That's it, I'm the petitioner. No, let me submit. When I filed my initial petition on,
Unless you answer our question, we will not proceed forward. That's not the way you address the court. Now we are asking you, how are you concerned with this? Whether you have the locus to challenge?
yes, Lordship, because tender clauses are violated, as a result, I could not participate. That's the issue. Therefore, Lordship, kindly see the order dated, I mean, page, I mean, is 27. Page 37 order, may kindly put it. Page 37, please. Locus will come only when, Lordship, but locus has been after continuous of 34 months, now
Did
saying
you
that.
have a proper license which had not expired or which was renewed?
No, Lordship, there are two things. One thing, not having registration in the department, other thing, not having renewal.
And the work has been completed. Is it correct?
No, sir, no.
Lordship,
The work is already completed.
no, I am not challenging the work. What I am saying, by filing 2485, I am challenging that the authority who invited tender on behalf of Governor of Assam, he had no competency.
So therefore, the option that you're suggesting is that we should direct for demolition of that
No,
structure.
no.
Because the initiation of the
No,
tender was bad.
No, Lordship, kindly submit. There's a provision, when Article 299 affects, then there's a provision, the contractor who did the work, he can move to the court under section 70 of the Contract Act for relief of payment to get the payment. It does not mean.
Mr. Bhattacharya, we are not able to understand this. It's no public interest litigation. Correct. You are challenging a decision on the assumption that the tender conditions were tailor-made to suit somebody.
That is true, only one bidder is there.
So the difficulty, one bidder is there, you should challenge now, the work is over. What do we do?
No, but work is over. I am not saying.
What is your prayer now?
Now, my prayer is that the work which is already completed, that should be declared as void because it violates Article 299. Secondly, let's submit. Secondly, the aggrieved contractor, he may move filing another petition under Section 7 of the contract to get the penalties. That is the provision in Constitution. There's a constitutional provision. Constitutional provision we cannot waive. Constitutional provision is mandatory. We cannot waive at any point of time. Even Supreme Court cannot waive. There is a violation that tendering authority cannot invite the tender on behalf of Governor of Assam when he is not no competency. That is the thing. So, Constitution is very clear here. Let us go to the Constitutional provision 299. Constitution says if any work is done in violation of that provision, that is declared to be as illegal and void, and the contractor who executes the work, then he can move under Section 70 of the Indian Contract Act for his release of the payment. That is the provision. So now, knowing the fact fully well, there is a violation of the constitutional provision. Can you challenge the constitutional provision? Are you competent to challenge the constitutional provision? At least let them submit their application. No?
Unless we are satisfied that this appeal is maintainable at your instance. In fact, the writ petition should have been dismissed in one line.
But it will continue for 34 months. And you see, page lordship, very important, page 369. There is the imprisonment of party, say page 369.
This only makes us feel that the institution of lawyers is so very necessary for the court, for the functioning of the court. I can't even make you understand. Now, according to our estimation, this is nothing.
That means
I mean, you have got no authority to question this. Now, you had not participated in the tender.
no, how can I participate? That tender can file it.
Mushkil hai. If you would argue like this,
Lordship, kindly.
because you're appearing in person, we will don't try and stretch our limits of patience. No, we are always very considerate towards parties who appear in person. But does it mean do we require to let you know what the law is? You have talked about Article 299. We have heard it. Now the question is this. Now basic question. Forget about law. Forget about 299 and anything. Now your consideration, your core grievance was that the tender conditions were made so onerous that only few persons could have done, and it was changed in three different tender works.
Two.
And you say that it was one single work, it was deliberately done so as to avoid any competition. Correct. This could have been questioned at a time when the tender was issued. Now, this was questioned. Now, concessionaire was selected, nothing happened, and the work has been completed. Now, do we enter into it now? Number one. Number two, apart from the tender conditions, did you have your license?
My license already, at least see page order of the judgment.
If you are
19, para 19 of the judgment.
find any merit in this.
Para 19 of the judgment, please. Para 19 of the judgment. And this was never raised by them earlier.
Will impose a cost upon him for this frivolous litigation.
That is up to your, how can I say what up to? But facts remain. Facts remain.
You don't find any merit in this appeal. The appeal is dismissed.
Item 16.
Lordship, the matter has become infructuous because the person has been released in the meantime.
Following the tribunal's order.
I got the instructions to appear in this matter, Miller. Fine, Miller.
On behalf of?
The sole respondent. It's a very simple case, Miller, wherein everything was approved. They are unnecessarily proceeding the matter.
We would have taken a different view. We would have taken a completely different view, Mr. Das.
I would have satisfied you.
Now, this mutual transfer we follow. Condition was that the reliever should come for some reason or the other. And why should we notice the other reliever?
No, there was no condition. The DRM had approved.
The condition was, but otherwise, this kind of mutual transfer is a favor which comes to you, which is, you know, invoked by you, and the department does it because of some rule, because of some permissibility of this kind of mutual transfer.
Yes, ma'am.
It does not happen, it does not happen. Otherwise also it should be stopped. It creates a lot of
It is-
problems otherwise. We would have taken a different view. Now that you have been relieved, he is withdrawing the
I'll get
petition,
the
it's all right.
yes.
Good for it, but no intervention otherwise. Again, the Mr.
Chakraborty, P. Chakraborty.
Mr. Chakraborty, 11 C2C. Suggests that this petition has become infectious in view of the respondent having been released to join at the place of posting, which was decided on mutual ground. On the, on mutual transfer ground. Yeah. Dismissed as having become infractious.
Item 17.
Please, your lordship, my lord, after filing of this writ petition, my lord,
Yes.
yesterday night, my lord, I have been communicated that the authorities have already passed an order of punishment against the petitioner.
That is what,
And-
that was the question which should have come to our minds, that what is the status of the departmental proceeding?
Yes,
So you need to challenge that.
I need to challenge that, my lord, but so far as this matter is concerned,
So you withdraw this petition
my lord, there may be a difficulty, my lord, if I withdraw the petition.
with the liberty to challenge the order
No,
of punishment.
that remedy I'll have to pursue, my lord, to challenge the order of punishment. But here in this proceeding, my lord, the learned tribunal has returned certain findings, my lord, that may come in my way. Unless and until, my lord, your lordship
No, no,
examines it.
once you, tribunal has come with finding.
Tribunal has given a finding that my certificate is fake.
Where is that?
Lordship may kindly come to page 139. Paragraph 17. And interestingly, my lord, 12th of May, this order was passed, and 14th of May, the termination order has been issued. Without giving me the inquiry report, without giving me any chance to.
Page 139, where is it?
113, para 17. The next paragraph also, your lordship may kindly see para 18.
The only way out for you is that you amend the pleadings of this writ petition and bring that on record, the punishment. That we permit, both together.
Yes. But if your lordship can give me some time, by Monday, I will complete it, my lord, if your lordship takes it up on immediately thereafter.
No, where is the article? Next June. Sometimes in June.
The consequence, the situation is that, my lord,
You have been ousted, no?
no, that, why I am saying so, my lord,
It was a harsh decision. After so many years, they come out with a plea that your matriculation certificate is false. But the difficulty is that if it is found to be false, then we can't possibly do anything.
no, my lord, the situation is why I am pressing for an early date, my lord. The reason is that, my lord, initially I was appointed as a casual employee. And thereafter, my lord, pursuant to this regular process of selection, I was appointed as the regular employee. Now, if the regular employee, the allegation is that while I was selected as a regular candidate, then this certificate had come in. Now, consequence will be if the certificate is fake, I'll go back to the original position of the casual employee.
That is a proposition which you advanced before the tribunal, and tribunal did not agree to it. We can't possibly do that.
No, my lord, that was not the, my lord, that was not the situation.
When you get into regular appointment, the casual vacancy occupied by you was over.
No,
Now, either you lose your job or you remain in job and the findings are found to be incorrect.
my lord, in the casual vacancy, I was given a permanency.
We cannot order for that. Now, we have our own limitations. We can't order for that. Well, if she's not a matriculate, then let her be only a casual worker as a air hostess or something. No, as a monthly rated female attendant.
No, as per the.
I mean, we have to understand what is salary of rupees 500 per month. And how did you become regular? Did you appear in any examination?
No, my lord, it was, I had challenged initially, my lord, 2002, in the year 2002, they terminated me. I challenged that order before the tribunal. Tribunal had ordered in my favor, directed to grant me the permanent status because they have a set of rules in the department by which, my lord, a person's putting up more than 240 days of service is entitled to permanent status. Thereafter, in the year 2004,
Tell
by
me one thing, the post of civilian Laskar, does it require a person to be a matriculate?
yes, my lord,
Then,
that it requires.
then you had an order in your favor by the tribunal. You were made permanent. They had already, terminated your casual engagement.
They granted.
They granted you in the year 2004
Four.
on the orders passed by the tribunal.
Yes.
Correct.
Yes.
So therefore, if you say that the rules were followed in making you permanent, even if you were not a matriculate, you would have acquired that degree later. But unfortunately or fortunately, you claimed yourself to be a matriculate, which certificate was found to be false.
No, my lord,
Whether it was false, whether the assessment and inference is correct or not, we will see.
my lord, they say when I applied for the post of civilian Laskar, then I submitted a certificate which was different from the original certificate held by me.
Correct.
So
If there are two certificates bearing two different entries with respect to the year of passing the examination or with respect to your age, both become suspect.
now
Now, we are not closing the chapter now. We are not stopping it here. You challenge that along with this. Time you want, you want an early date. We'll give you an early date.
that's why, my lord, if you
We'll give you an early date.
next week, Wednesday, my lord, by then, my lord, I'll make the amendment in the pleading.
We have heard Mr. S. Datta, learned senior advocate for the petitioner. The petitioner was engaged as a monthly rated female attendant with respondent number 2 at a salary of rupees 500 per month. The petitioner was engaged in the year 1995. In 2001, her services were terminated, which termination was questioned by her before the Central Administrative Tribunal, Gauhati. The termination order was set aside and the employer was directed to consider the case of the petitioner for permanent employment as per the rules. Based on that order by the tribunal, she was declared permanent in the year 2004. After serving for quite some time, she was appointed to the post of civilian Laskar in the year 2012, which promotion was obtained by her only after appearing in a selection process. After about 3 years, she was served with a show cause notice asking her to explain the circumstances under which she had submitted a forged SLSC certificate at the time of her appointment as Laskar. It appears that the petitioner denied those allegations and also raised the plea that the documents were verified at the time of her original engagement, which was accepted by the department. The explanation by the petitioner was not accepted, and she was served with memo of charge. The departmental inquiry ensued. The petitioner thereafter chose to challenge the show cause notice and the charges framed against her before the tribunal by OA number 040/00014/2018. An interim order was passed by the tribunal that no final order with respect to service of the petitioner shall be passed by the employer without the leave of the tribunal. However, later, the OA of the petitioner was dismissed. During the pendency of the present writ petition, Mr. Datta has informed this court. Mr. Datta informs this court, the departmental proceeding has ended in punishment to the petitioner, and she has also her services also have been terminated. Mr. Datta in such circumstances submits that he be permitted to question the punishment as also her termination in the same writ petition, for the reason that tribunal, without sufficient material before it, has returned a finding that the certificate of that the HSLC certificate offered by the petitioner at the time of her appointment was fake. Unless this finding also is rebutted, the petitioner would have little chances of succeeding in would not be in a position to mount any challenge to the order of punishment as also of termination. The petitioner in that case would be required to amend the pleadings and also bring the two orders on record by way of an affidavit. Let that be done on or before the next date. Re-notify sometimes in June. When do you want it? May is ending.
I said next Wednesday.
Next Wednesday would be too early. You would not be ready with your.
Well, I'll try to put some effort in it.
Keep it on 10th of June.
Much obliged.
The one thing, Lordship, that it's not during the pendency because the order, as per my learned senior, is 14.5 and a petition is filed 18.5. 18.5.
I got it 20 on. It is on 20th. I got it.
During the pendency, he got the information. During the pendency of this writ petition, the petitioner was informed that the department proceeding has concluded, which she has been saddled with punishment, and she has also her services also has been terminated.
Lordship, can it be on 8 or 12? 10, a little difficulty.
12.
Obliged, ma'am.
Give her a copy in advance.
Well, yes, sure.
In this case, Lordship, after a lot of deliberations, we have procured some of the materials from 1983. So I will receive the instructions last night. So we'd like to file an affidavit, maybe 1 or 2 weeks, maybe.
At the request of the learned advocate.
Not it, if the date maybe after 12th of July. The submission will come out.
Why not?
After 12, then let it be in the first week of August.
At the request of that victim who has submitted that some information has been collated regarding 1983 Nelly massacre, which would be required to be brought on record. The matter is adjourned to first.
5-8. Item 19.
Time until Wednesday next, coming Wednesday.
Third time,
Last chance, my lord. It may be recorded in the order.
Did we pass any order?
I sought time on the last occasion, my lord. They said
Last time,
last time.
As prayed for by Sumitra Sharma, learned government advocate. Let this matter come up for consideration on next Wednesday, on 3rd of June.
Deeply applied.
Item 20.
I am representing myself in this case. This is regarding.
Seat, you also get a chamber. Let the new building come up. What do we say? What do we say to them?
You are not the only one.
Are you the only person who requires a place in the Wakalat Khana?
No, there are so many of them.
We'll have to-
When I started my practice in the year 1991, I had no place to say.
Same for everyone, Miller, the same.
Everyone.
Space constraint.
That
these are-
scooter stand.
Exactly, sir.
And you're an
Backside.
You think you can invoke this Article 226 for a direction? To the bar, you go before bar council and say that you pay your fee, everything, and then you're not afforded a space.
No, this matter is to bar association.
How many years have you put in?
Almost 3 now.
Almost 3. I could get a seat. I mean, I'm not asking you to follow my example, but I could get a seat allocated to me in one of the associations only after 3 years. It all depends. And my senior's place was in a different association. We had 3 associations: lawyers, advocates, and barristers. And I got a seat in barrister association, not necessary for a member to be a barrister. It is named like that.
Your Honor, still, the respondents have not put in their appearance.
We are only being indulgent to you. Not discussing.
The respondents.
Go and talk to the local state bar council.
Yes.
If you have any grievance against them, or you meet the president, ask him to allot some place, join a senior's office, you will get a place. See, we are not immediately, discarding your petition for the reason that all of us, in fact, everybody sitting here would have passed this phase.
Yes.
And it is precisely for this reason that we have made arrangements for how many chambers have been thought of? More 1,800 chambers we have planned.
Still, that would be far less than the capacity because
Many things.
the bar association has a present capacity of more than 5,000 people. 1,800 would be still less. We need a streamlined policy, Your Honor.
Mr. Borpuzari, don't ask us to say many things in this petition. Don't press this. We discuss this petition with the liberty. You don't need our liberty. You go before the president of the association, or you can approach the bar council. Not a matter to be agitated.
It does help me.
Yes,
But he's asking for too much.
I understand.
Otherwise also there are many advocates amongst us.
I mean, are we outsiders to this profession?
No, absolutely.
We know this, no? Generally, even senior lawyers, senior, not designated senior lawyers, but fairly senior in their own right,
Space scarcity is always there.
they are compelled to take their lunch in their cars.
Exactly.
If there is no space, what is to be done? And when we constructed about 500 rooms in a separate building, the associations started fighting. And then in that, I mean, there was some dispute with respect to, inauguration, who would inaugurate. There was some dispute and now the government has withdrawn the assurance that they will give electricity fee and all that. So it is all lying vacant in Patna.
Yes.
These are the difficult things. If he is allotted a seat, the others will come and clamor. If you can tell us that all persons, even junior to you, all persons who have joined bar, they have been allotted different seats, we might consider. Can you say that? Anyway, we have said much. This is only for the benefit of the advocates that we said don't press this. See, there was War Pujari, learned advocate. There was his War Pujari advocate who appears in person. After some argument, seeks permission to withdraw this petition in order to approach the office bearers of the association or the state bar council for the needful. Debut dismissed as withdrawn with the liberty of aforesaid.
Item 21.
Happy to Lordship. 21 matters I appear on behalf of Mr. P.N. Goswami. He is seeking some time, his auspicious.
As prayed for on behalf of Mr. P.N. Goswami, learned senior advocate slash additional advocate general Sam, let this matter come up for consideration on after 3 weeks. Okay. In the meantime, ask him to file an affidavit for the settlement, any settlement plan, anything. There have been
My lords, we
we
are
have to put to
communication.
the vagaries of nature.
My lords.
And they were settled there for about 40 to 45 years.
Yes, my lords.
Only for that.
Right.
It is a reserve forest. They have to come out of that place. But with some arrangement,
My lords, we understand.
we'll see.
22-6. Item 22.
Thank you, Lordship.
Yes, Mr. Shah.
My lord,
You have not rolled it out, have you? The new act,
yes, my lord.
has it been notified?
Yes, my lord.
It has been gazetted.
Notified.
That is also under challenge in some.
Yes, yes. There are cases pending. One
Rules
case
is not
my lord.
framed, I think.
My lord.
Rule is framed.
Rule is under process.
Let this matter be listed along with, when is that petition?
That is WPC number 6428. 24.
And to be listed on which date?
No, that fixed. Mr.
These
AR
are complex, my lord.
Huh?
These are complex. No date fixed. my lord.
Not HRH.
Uh-huh.
Just check up.
Challenge to the act.
Where there
Yes.
is this case to be listed with that case in which Mr. H.R.H. Chaudhary, he's there for some Qazi or all. List this along with so and so on so and so.
My lord, I have interim prayer in this petition because this period within 24 to 10.
Anyway, we'll see.
My lord, actually, they are a vacuum period. They cannot register them either in either I
There
or in
is a special
No,
marriage.
there is no bar having your marriage registered in the.
Qazi Act already. Qazi has been demolished. My lord.
Anyway, we'll see it then.
Strongly understand.
Okay. Six, 4, 2, 8.
6, 4, 2, 8,
24. 6, 4, 2, 8.
24.
No problem.
Yes.
Item 24.
Yes, sir.
In this case, last occasion, my lord, I attend my lord, submitted some bills to verify. I've sent it for verification. Some time is required as per my instruction.
But Mr. Ganguly, can you claim it as a matter of right?
But
You have been given 5 lakhs, no?
we have been given five lakhs, but the admitted case before the learned single judge was that I have spent far too much money.
In fact, my lord, as per the public law policy, there is a notification. As per that notification, my learned friend's client entitled only for 1 lakh.
That
No, that we
notification is
understand, but problem is this, your admitted position was that he was not part of the move. So that's why you come at least give me whatever is spent.
that is
That
That's
is why
why we
I
say
said,
that is what.
we're not challenging the, my lord.
Anyway, at the request of Mr. D.K. Sharma, learned additional senior government advocate, let this matter come up. 3 weeks more?
After 8 weeks, my lord.
After
8 weeks, my lord.
8 weeks.
My lord, as
Or medical document. will verify. Notify on 8 weeks. के बाद
public.
12 August. Item 29, supplementary.
Yes. That we should notice to the person. no?
There was no see. The relevant point of time when was appointed was.
Again, we have heard Mr. K. Gogoi for the appellant. Plus state of Assam for the appellant, for the appellants, plus state of Assam and others. By the impugned judgment. Dated 23/10/2025. It has been directed that the respondent number.
One lawsuit. One. Yeah, one lawsuit. One.
No, the respondent number, who is the private party, the writ petitioner? Sole response. Respondent number 1, respondent, co-respondent. Slash writ petitioner. Be extended the benefit of UGC scale of pay from the date of his initial appointment from 8/7/1994. By the impugned judgment, the appellants have been directed to carry out the exercise of calculation of the arrears within a period of 2 months from the date of receipt of certified copy of the judgment. Mr. Gogoi submits that such decision is against the UGC rules and regulations. and the service condition of the respondent. Let notice be issued to the respondent in the main appeal, as also in the stay application, right, IA number so and so, on steps being taken by the appellant / applicant within a period of 2 weeks, both modes, returnable on. We keep it in July, lost, returnable on so and so date. So till such time, the operation of the judgment in tune shall remain in the case.